Get ready. Start. 24. We are of the view that the judgment of this court in Jonas Woodhead and Sons in bracket Supra would not come to the aid of the respondent SSE because the issue before this court in the said case did not relate to a single right wherein the payment made towards the same was held to be partly capital and partly revenue. Full stop. The purpose of payment in the said case was traceable to two different subject matters and therefore apportionment between capital and revenue expenditure. Full stop. However, in the present case, the entry fee as well as variable license fees are traceable to the same source. Full stop. Similarly, this court decided the nature of expenditure on two separate transactions, though payments made were consolidated in nature. Full stop. The first transaction related to the compensation paid by the principal for the termination of agency business, while second was with respect to the payment made towards the non-compete clause. Full stop. On the first aspect, namely the compensation received for the loss of agency, it was held that what would be determinative was whether loss of agency would affect the entire business structure, resulting in a loss of enduring nature, or whether it was a loss due to an ordinary incident in the course of business. Full stop. If it was the former, it would be capital, and if it was the latter, it would be revenue in nature. Full stop. It was concluded vis-a-vis the first transaction that the loss of the said agency by the SSE was only a normal trading loss, and therefore the income received in this regard was a revenue receipt. Full stop. As regards the non-compete clause, it was held that the same was a restrictive covenant and was therefore capital in nature. Full stop. In paragraph 14 of the said judgment, it was recorded in unequivocal terms that the compensation paid was in respect of two distinct matters, one taking the character of a capital receipt and the other of a revenue receipt. Full stop. Therefore, this is a case where two independent transactions were considered, one of which was held as capital and the other as revenue. Full stop. This case did not decide the expenditure towards the same right to be partly capital and partly revenue. Full stop. Paragraph change. 25. We shall now consider the decision of the Madras High Court affirmed by this court in Southern Switch Gear Limited. Full stop. Paragraph 2 of the judgment of the High Court records two distinct transactions. One for provision of technical know-how for the manufacture of switchgear products, and the second was to share modern developments and also train necessary personnel in the factory in United Kingdom. Full stop. The consideration was fixed £20,000 payable in 5 installments of £4,000 each. Full stop. Paragraph 5 of the judgment of the High Court referred to clause 6 of the agreement, which dealt with know-how, and clause 7 thereof, which dealt with supervision and direction. Besides recommending appointment or dismissal of employees and also training them in the factory, full stop. In paragraph 6, it was held that expenditure on technical know-how is capital in nature and should be apportioned at 25% and the services rendered relatable to 75% of the consideration was revenue in nature.